This is Bloomberg Law with June Grasso from Bloomberg Radio.
The federal judiciary is considering whether there should be more guidance for judges about hiring law clerks after two judges hired a clerk who was reported to have sent racist texts, and that clerk then went on to get a clerkship with Supreme Court Justice Clarence Thomas. Joining me is an expert in legal ethics, Arthur Hellman, a professor at the University of Pittsburgh Law School. So House Democrats in 2021 had filed a complaint against Chief Judge William Pryor of the 11th Circuit and District Judge Corey Mays of the Northern District of Alabama into the hiring of this clerk. Tell us about the controversy and what ended up happening.
Well, the controversy centers around the investigations that judges Pryor and Mays, the circuit judge and the district judge, carried out with respect to this individual. As I understand it, the question is whether they adequately vetted her before hiring her. And the chief judge of the Second Circuit, to which the proceeding was transferred, found that they did all they were required to and dismissed the complaint, and the Judicial Council of the circuit affirmed that dismissal. So the proceeding was completed, but the Committee of the Judicial Conference of the United States thought it should be reopened, and that's what gave rise to one of the requests at the March meeting of the Judicial Conference to look into that review process. So we have two separate issues here, one that involves the Committee on Codes of Conduct and the other that involves the Committee on Judicial Conduct and Disability.
How much investigation of clerks should judges be doing?
Well, I think that's one of the issues that the Committee on Codes of Conduct will be looking into. What is due diligence in this respect, and what are the ethical obligations of a federal judge? It's important to emphasize that the Committee on Codes of Conduct is tasked with interpreting and giving guidance based on the code of conduct. It is not otherwise in the business of telling judges how to run their chambers, although here the two overlap a little bit. But for example, is it enough that the judge asks the clerk, is there anything you've done in the past that would embarrass you or me if it came out now? Or should the judge carry out his or her own investigation? Now, I don't do much social media myself, so I'm not really the person to talk about that in detail, but my sense is that a thorough background investigation of that kind would be very time-consuming and laborious, and I'm not sure a judge should be expected to do that. A judge should be able to ask the law clerk if there is any such material in the clerk's past and take the clerk's word about that. But the Committee on Codes of Conduct might decide that something more than that is required. But their task at this point is to consider the process by which judges hire their law clerks who may have something in their past that casts doubt on the fitness of the clerk for present service as a law clerk to a federal judge.
How long might this process take?
That, I think, is one of the issues that the committee will have to consider. I mean, this is not the major thing that a judge does. I mean, it's a very important part of the judge's work, but the judge is nominated and confirmed to decide cases. So every minute that is taken away from those tasks, the judge is not doing what he or she was nominated and confirmed to do. So figuring out how thorough the investigation should be and whether there are any particular things a judge should do in checking on a law clerk is one of the questions that the Committee on Codes of Conduct will now be looking into.
I also wanted to get your position on the conservative federal judges who announced they were going to boycott hiring clerks from particular law schools where there were demonstrations and disruptions on campuses. These are law schools that would be considered liberal. So just eliminating a whole block of students because of what happened on their campuses.
Well, that raises some related but distinct and very interesting and important issues, actually. I think a key to this is why the federal judges are taking that position. For example, a judge might say, if a student has gotten his or her legal education at a law school that discourages dissent and allows raucous intrusions on presentation of unpopular views, that environment diminishes the quality of the education that the student gets. Because an important part of legal education, an important part of legal reasoning is listening to other views and processing them and responding to them in a professional way. So a judge might think the person in his chambers should be somebody who's gotten a legal education that is not tainted in that way. And, maybe we should back up a minute because it really relates to both of these topics. Federal judges today have very, very heavy workloads, and they're very heavily dependent on their law clerks. So it's important that these clerks have gotten the best possible training. So as I say, if the judge believes that some of the practices at a particular law school diminish the quality of the training, I think that would be a legitimate job-related reason for not hiring students from that law school, even though it is, in a sense, unfair to the students. Although, if you look at it more broadly, you talk about boycotts. There are many judges who hire their law clerks only from, let's say, top 14 or top 20, whatever it is, law schools. Are they boycotting the other 180? I don't think we would ordinarily say that. We'd say that the judge has decided, rightly or wrongly, that the most effective way of finding good law clerks is to stick with a small number of elite law schools where they know some faculty and can rely on recommendations. So if the reason is related to the carrying out of the judge's adjudicative responsibilities, I'm not sure I see a problem in that.
Choosing law clerks from the best law schools because you think that they'll be the best clerks seems different to me than not choosing students from top schools like Stanford and Yale because some conservative speakers faced blowbacks on campus.
It may be problematic if the judges are doing this to change the culture in the law schools. I say maybe because judges are allowed to write and speak out on the improvement in the legal profession. And maybe it's part of that, or a small step further, to say that judges can hire their law clerks in a way that they believe will improve the culture at law schools. But that's a very different kind of motivation or purpose. And that one, I think, would be more controversial. As I say, I think you can make a case that that is legitimate within the code of conduct, but other people might say that it looks like using the judge's position to advance the judge's personal interests, which is one of the things that the code explicitly prohibits. So it's a question of how you view that. Is it a way of improving the legal profession, which is something the judge is explicitly allowed to do under the code, or is it advancing a personal interest, which is something the judge is explicitly prohibited from doing?
I'll just note these conservative judges were Trump appointees. Did they face any consequences because of this?
I think possibly a complaint has been filed. That was a while back. I'm pretty sure no order has been issued. Certainly, there have been criticisms from other judges about the so-called boycott. The grounds have been along the lines that I suggested, that the judges are using their position to change the culture at law schools, and that's a misuse of the judicial position, that judges should be concerned in their hiring only with getting the best people for their chambers.
Let's turn now to the resignation last week of a judge in Alaska over allegations of sexual misconduct. A federal judge in Alaska, Joshua Kindred, resigned and could face impeachment after an investigation found that he had an inappropriate sexual relationship with a female law clerk and that he created a hostile work environment and appeared to have no filter in his discussions with clerks, discussing his romantic preferences, his sex life, his divorce, the law clerk's boyfriends, and dating lives, on and on. The investigation by the judiciary into the Trump appointee resulted in a 105-page report with more than 1,000 pages of exhibits, including 700 pages of text messages between the judge and his clerks. The inquiry could lead to the reopening of multiple criminal cases that came before Kindred during his more than 4 years on the bench. I've been talking to legal ethics expert Arthur Hellman, a professor at the University of Pittsburgh Law School. So there was this outrageous conduct, but it took almost 2 years after the chief judge learned about it for the judiciary to complete its investigation. And in those 2 years, there were criminal cases that came before Kindred. And now these findings could lead to the reopening of many of those cases and others.
Well, it is somewhat puzzling because the evidence as presented in the Judicial Council report is so strong. You would think it would not have taken almost 2 years to find all that evidence and to come to a conclusion that this individual was unfit to serve as a federal judge, the conclusion they reached when they referred the matter to the Judicial Conference of the United States for consideration of possible recommendation to Congress for consideration of impeachment. That is a little hard to understand. What may be is that the people they talked to were initially reluctant to speak out. And if that's so, it really raises some very troubling issues because, as you know, what was it, 5 or 6 years ago now, the judiciary completely revamped its procedures regarding the workplace in the wake of the accusations against former Judge Alex Kozinski. And I have to say, I thought they had done a pretty good job and that they were really trying to create, as Chief Justice Roberts put it, an exemplary workplace in every judicial chamber. And particularly in the Ninth Circuit, which has been a leader in this, as in so many other administrative aspects of the federal judiciary, that this took that long to get resolved is very troubling. And I think it does call, alas, for another look at how the judiciary is handling this very important aspect of the administration of the federal courts.
The repercussions from this are going to be enormous. Federal prosecutors in Alaska have identified nearly 24 criminal cases with potentially undisclosed conflicts of interest involving former Judge Kindred and the attorneys who worked on the cases before him. 3 of those are in the U.S. Attorney's Office.
Well, I'm not an expert on federal criminal prosecutions, but what I will say is that that aspect of this particular case underscores the point you made initially, that there was a particular reason here for proceeding with some swiftness, giving all due process to the judge. But there were some particular reasons here why the matter should have been resolved as quickly as possible so that these repercussions would be minimized.
The judge did recuse himself in some cases. How is it determined whether there was a conflict of interest?
Well, what the statute says is, apart from some specific circumstances where a judge must recuse, for example, where the judge has a financial interest in the outcome of the case, the more general provision says that a judge must recuse if a reasonable person would doubt the judge's impartiality. And judicial interpretations of that statute, Section 455, have said that you look at that question from the standpoint of a reasonable person outside the court, but informed of all the circumstances. So those are the elements of the test. It's an objective test. Again, it's a reasonable person, but not a person within the judiciary, because the courts have said that people within the judiciary may be too inclined to discount the possibility that a judge would look partial or biased. So you look at the reasonable person outside the judiciary, but at the same time, the reasonable person is fully informed of the circumstances. And so the judge has to put himself or herself in the position of that reasonable person.
Can you think of another case where there was misconduct like this by a judge and criminal cases got thrown out or retried?
No, nothing comes to mind. I mean, you do have a somewhat parallel situation with the bankruptcy judge in Texas, don't you? Where they are in the process of upsetting, I think, or at least questioning some of the decisions made by the bankruptcy judge who was in a romantic relationship with a bankruptcy lawyer. So I think that is comparable. You mentioned the repercussions going forward. I think one of the most interesting questions and important questions about the Alaska judge is, how did this person get to be a federal judge? I mean, this is a young guy, and this kind of behavior seems to me not the sort of thing that suddenly happens, that a person suddenly engages in. And you would think that there would be some evidence of this in his career and his behavior as a lawyer. Now, as you know, before somebody is appointed to the federal bench, there's a very intense investigation. And it's more than one. There's the FBI, there's the White House, there's the ABA. The FBI in particular is very thorough. For example, I've gotten calls about people who worked for me briefly 30 years earlier, because the nominee is required to list every person he or she has ever worked for. So how did Joshua Kindred get through that process? Were there no warning signals in any of the conversations that FBI agents or the ABA committee members had with members of the Alaska legal community that would have alerted them to the very real possibility, which turned out to be the reality, that this individual just did not have the temperament to be a federal judge? Now, by the way, you had a similar failing 25 years ago with Judge Porteous, who was impeached and convicted for actual bribery and other criminal activity that he had engaged in for many years in Louisiana, and which has to have been known by many of the people in the Louisiana legal community. That was another failure, in my view, of the vetting process that, as far as I know, nobody has ever looked into or written about. But I think there's a serious concern here that the vetting process at the nomination/confirmation, and it's really nomination, you don't expect the Senate Judiciary Committee to carry out the kind of in-depth investigation that the FBI, with all of its resources, can do, or that the ABA can do with its members in every state and every legal community. Those two organizations have the resources to carry out in-depth investigations, and we really have to depend on them. In all likelihood, they missed this. Now, it's possible that he had a complete personality change on the bench, and there's some suggestion that the isolation in the COVID lockdowns had some influence. But, isolation doesn't turn a man into this coarse, speaking individual who harasses women in the way he did. Even to read about his behavior, it's an embarrassment. And behavior that extreme, it seems to me, doesn't start overnight or when a man takes the oath as a federal judge. There have to have been some signals in his earlier behavior that should have been caught. So I would hope that one of the consequences of this very sad and unfortunate proceeding is that there will be a look not only at the procedures within the federal judiciary, which we haven't talked about, but within the executive branch and the vetting of judicial nominees.
Considering all the information out there about hostile work environments and the legal cases over it, it's almost hard to believe that this judge didn't recognize what he was doing.
Going back to our prior discussion of the Ninth Circuit and the federal judiciary putting new procedures in place, is that it may be that the panoply of procedures is possibly part of the problem now, because one of the things I think that is absolutely essential is that there be one person who is responsible. If everybody is responsible, then nobody is responsible. And here it's the chief judge. And I don't know if the chief judge adequately conveyed the message that if a federal judge is misbehaving, I want to know about it, I will take action, and I will make sure there's no retaliation.
Thanks so much for coming on the show, Arthur. That's Professor Arthur Hellman of the University of Pittsburgh Law School. Coming up next on the Bloomberg Law Show, articles of impeachment have been filed against Justice Clarence Thomas and Justice Samuel Alito. They're sure to fail, so what are the repercussions? I'm June Grasso, and you're listening to Bloomberg. New York Representative Alexandria Ocasio-Cortez has filed articles of impeachment against Supreme Court Justices Clarence Thomas and Samuel Alito for what she said was their failure to report gifts and refusal to recuse from cases in which they were conflicted. Progressives and others have criticized both justices over reports they accepted vacations from wealthy people and failed to recuse from cases despite conflicts they said were created by their spouses. The success of either resolution against arguably the court's two most conservative justices is unlikely given the Republican control of the House. The New York Democrat and Maryland Democratic Representative Jamie Raskin wrote to Chief Justice John Roberts on June 20th, urging him to investigate Thomas and Alito. Democratic senators have sent similar requests to the Chief Justice. Of course, the Chief has taken no action. Joining me is an expert in impeachment, Frank Bowman, a professor at the University of Missouri Law School. So tell us about the articles against Thomas.
Well, there are 3 articles that have been filed by Representative Ocasio-Cortez and some of her colleagues. Essentially, they allege that Justice Thomas really improperly refused to recuse himself from a variety of matters based on 3 things. The first article has to do with his receipt of gifts from Harlan Crow and other folks broadly associated with the American Enterprise Institute and other conservative entities. The argument there being that these entities at least file amicus briefs in matters that appear before the court, even if they're not parties, and thus they have an ongoing interest in the outcome of cases in the court. The second article has to do with Mrs. Thomas's professional activities. She has, over the years, had various consulting arrangements or consulting entities, which are sort of interwoven in the conservative legal political movement, and various folks in that constellation of people and enterprises and think tanks and so forth have funneled money to Ginny Thomas through her entities. And here, too, the argument is that Thomas should have recused himself in any matters in which any of the various entities that have funneled money to his wife might have filed a brief. or have some sort of interest. And the third one is the one which probably has the most bite to me, and that's one in which the argument is that Justice Thomas should have recused himself essentially in all the cases that had anything to do with Trump's effort to overturn the 2020 election results because his wife was involved in the Trump coup attempt. Now, the degree of her involvement is a little bit unclear, but she certainly was actively advising various people, including White House chief staff and others, about how to proceed during Trump's effort to overturn the election between November 2020 and January 2021. And the argument there is, your wife, Justice Thomas, is actually, directly involved, albeit not at the center, but directly involved in this, in effect, conspiracy to overturn an election. And you have no business ruling on the merits of any cases involving that coup, whether they involve Trump, whether they involve any of the other people who were charged, or just the general issues that are raised by that coup attempt, because there's certainly a reasonable inference to be drawn that you're not impartial in these cases because, A, your wife was directly involved in this. She was potentially at least a witness, indeed was a witness in front of the January 6th committee. Arguably, she could have been a defendant. She has not been charged, of course, but she was certainly potentially a defendant in any case charging a criminal conspiracy arising from January 6th and its antecedents. So those are the three arguments against Thomas. I think the first two are at least undeveloped. The third one is a stronger case for recusal, certainly, and thus maybe a fractionally stronger case for impeachment.
By contrast, the allegations against Justice Samuel Alito are shorter. Explain those.
Well, I think they're really, really, really thin, both factually and on a constitutional basis. In essence, they arise out of the flag controversy. In essence, the argument is, well, Alito or somebody in his family flew an upside-down U.S. flag and the appeal to heaven Revolutionary Era flag, which are in some circles associated with Trump or the effort to overturn the 2020 election. And that, by extension, is said to indicate that Alito himself had some sympathy with the effort to overturn the election, and therefore he had to recuse himself, and so forth and so on. And the two problems with that. One is that the facts as to who flew what flags when and why are extremely unclear. And you don't go around impeaching people on webs of supposition like that. And the second issue is a more difficult constitutional one. We've only impeached one Supreme Court justice in our history, and he was acquitted, Samuel Chase, in 1804, 1805. And Chase was essentially impeached for being a vocal Federalist and therefore an opponent of Thomas Jefferson's Republicans, and of saying and doing some things on the bench that suggested he had a very strong affinity for the Federalists. And he was essentially impeached for statements that he made, from some rulings he made in some cases. But the real argument was that he was an ardent Federalist and was letting that affect his rulings, his statements. And he was acquitted by the Senate, and we generally thought the meaning of that acquittal was that Supreme Court justices and other judges should not be impeached for their opinions. Now, they certainly could be impeached if they were overtly basing their rulings on partisan political affinity. In other words, they rule for Republicans because they're Republicans or against Democrats because they're Democrats. But there was no proof that that was true in Justice Chase's case, and the Senate finally concluded, we're not going to impeach people just because they're of the other party, were appointed by the other party. Indeed, there were arguments in that impeachment. One senator basically stood up and said, no, we think, and this is very early in the Republic, not quite 20 years after the Constitution's been ratified, and we weren't quite sure how we were going to treat impeachments. But the congressman stands up and says, no, we think that impeachment is to be used for precisely this purpose. You people have bad opinions, and we're going to get rid of you to put in your place, Justice Chase and others like you, people who have good opinions. And that view was essentially rejected. And ever since, we just don't impeach justices for their opinions. Coming back to Justice Alito, has he perhaps behaved intemperately at times? You bet, in my view. But, has he in any provable way acted corruptly? Can we prove that he ruled in a particular case based on his partisan political affinity rather than, his genuinely held jurisprudential convictions? Well, I don't think so. And so I think the article against him is both factually weak because it's based on disputed facts, and I think it's constitutionally extremely, extremely thin, if not non-existent.
So with a Republican majority in the House, this impeachment effort, there's no chance that it will even be voted on, let alone pass. So what's the point of doing this?
Well, I think this is a purely performative exercise, right? Because not only is the Republican House not going to impeach either Thomas or Alito, they're not even going to investigate the allegation. Now, I think that, there may be times when it's clear to, a majority of the members of the House that the Senate perhaps is not going to convict or is unlikely to convict on a particular set of impeachment allegations, but nonetheless makes logical and constitutional sense to embark on an impeachment inquiry into the House because it gives you an opportunity to investigate it, to bring forward facts about official wrongdoing. And I think that, in essence, the justification, certainly for the first Trump impeachment, where it was, at least reasonably probable that the Senate would not convict, but the Democrats felt, at a minimum, we need to use the special powers of investigation that arise in an impeachment situation to unearth the facts regarding Trump's connections with Ukraine and his effort to use Ukraine to secure dirt on his political opponent. I think that's arguably justifiable, even if you're not going to get a conviction in the end. But in this case, not only do we know that the Senate would never convict either Alito or Thomas, we know that the House as presently constituted isn't even going to open an investigation into these allegations. I think particularly when the allegations are themselves, I think, constitutionally pretty weak. As I said, I think the Alito case is thin to non-existent constitutionally. The case made against Thomas, particularly the first two articles, I think are very, very thin. And the third article is borderline. I think it makes very, very, very little sense to launch into impeachments where you're not even getting an investigation. I personally disapprove of using a constitutional mechanism as serious as impeachment as a means of political signaling, where it has no other function. I think that trivializes impeachment, and I think trivializing impeachment is itself dangerous. We're rapidly reaching that point if we haven't passed it. In days gone by, certainly the days of my relative youth, if somebody brought an impeachment allegation, that was serious business, and people who paid attention to national government pricked up their ears and said, well, golly, if somebody is seriously maintaining that this or that conduct by an official is impeachable, well, that's something we ought to pay attention to. We ought to at least listen to the case for impeachment. Impeaching people, or, filing impeachment resolutions when it can't accomplish anything, not even getting an investigation, seems to me a very bad idea. It just trivializes the mechanism of impeachment. It creates a situation where nobody even cares. And I think that's bad. We've already gone a long distance to rendering impeachment effectively useless against official misconduct. And I think this kind of thing goes further in that direction.
Thanks so much for joining us. That's Professor Frank Bowman of the University of Missouri Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.